Thank you.
Case number 54, People v. James Kadarko. Good afternoon, Mr. Wan. Do you wish to reserve some time for rebuttal?
3 minutes, Your Honor.
3.
Thank you.
Okay.
May it please the Court, Charles Wan for the people. Your Honors, here the trial court read the jury note as it was written, except for the numerical breakdowns. However, the court did tell the defense counsel that the note contained a breakdown of the votes as to each of the 5 robbery dates, and that the breakdown did not indicate what outcome the votes favored, and also told the defense counsel that there were 3 separate splits.
Do we know why the judge didn't give him the breakdown?
Well, the judge stated that he wasn't uncertain whether it was proper to give notice of the breakdowns. So in this case, the judge never stated that. Maybe
he didn't want to let them know that 2 of them were 11-1, that they were that close, or that 1 was 8-4.
Well, we don't exactly. I don't believe it was that the 2 of the votes were 11-1, because he just felt that it was unclear whether it was proper to give notice of the jury splits.
If the jury came back with a note that says we have a holdout, should the judge read that to the counsel?
I believe that in that case the jury should read the note. I mean, the judge should read the note as it was written. Here, we're not. The issue isn't that whether the note said 11-1 or not, but the judge, gave the sufficient details to defense counsel to have meaningful input. He told defense counsel.
If that's true, then why not read it? I mean, if there's no harm in it, if one side or the other has a feeling that the case has gone either well or badly for them, this would confirm that, whether it's the people or the defense, and that may affect them as to whether or not they want a charge or not.
I mean, it would have been best if the judge read the note as it was written, because then we would not be here. But even then, the judge did give all the details that was necessary for the defense counsel to have.
But doesn't Orama say in substance, don't paraphrase, read?
I would argue that here it was not paraphrasing, that all the details were given, that this is an actually case that has similar facts to this Court's decision in Starling, where although the Court did not follow the specific guidelines set forth in Orama, the judge did give the contents of the note, and although the judge read the note in front of the jury and instructed the jury without actually having offered defense counsel an opportunity, the Court said everything was proper. It was still the defense counsel still needed to have an object, and there was not a moral proceedings there because defense counsel knew what the judge would have stated.
There's no question that if this note had said who was in favor of guilt and who was in favor of an acquittal, that entire note had to be read, correct?
Correct, Your Honor. Then it would have been.
What makes it different here?
Because here, the notes did not indicate which way the votes were favored. It was similar as if it would have been the same as if the note just simply stated it was deadlocked.
Could an experienced attorney have made an educated guess as to which way they were 11-1 on certain counts?
It's possible, Your Honor, but it's still.
I mean, doesn't Orama say they're entitled to that kind of opportunity, to engage in that kind of strategizing?
Well, in Orama, this Court stated that the importance of reading the note as written is that the language and the tone of the note could give meaningful advice or input to the defense counsel.
And that would have given counsel an opportunity possibly to ask for a mistrial or whatever, or ask for a.
That's correct, Your Honor. Here, the 2 options counsel had was to ask for a mistrial or give input on what kind of Allen charge he wanted. And here, he did ask for a mistrial, and the Court also gave him an opportunity to give suggestions on what kind of Allen charge he wanted. So
what's the play judge for a minute? You're telling him absolutely everything about this except the numbers. And as you can tell from our questions, if you hone it down more specifically, everybody agrees they should know. And as Judge Smith said, I mean, you got 2 adult, pretty smart lawyers. I mean, what's the mystery of telling them exactly what's in the note? I'm missing what we're missing.
I'm not arguing that the Court should not have read the note as it was written. Our argument is that although the Court didn't give the specific breakdown, he did give meaningful notice of what the note stated.
Are you saying there was no error, or are you saying the error was so minor that it required preservation?
That if there was any error, it was one that needs to be preserved because this case is the same as in Starling. The error here isn't that the court did not give meaningful notice of the note. If there is any error, it would be that the court did not strictly follow the guidelines that set forth in Rama.
Did the defense attorney get to actually physically see the note while the jury was still deliberating?
Yes, Your Honor. The court told defense counsel that...
And did he make any objection or ask for a further instruction at that juncture?
No, Your Honor. Defense counsel never made any objections and never even asked for any kind of specific Allen charge. All he did was ask for mistrial. And then when the judge told defense counsel he was going to issue an Allen charge, as he had done before, defense counsel had no objections. And after issuing the Allen charge, in which the judge told the jury that they should not give up their beliefs just to reach an outcome, the judge showed the note to defense counsel, and he had no objections. Here,
is that part of this case why you feel the preservation rule should be different under this fact pattern? I'm trying to pinpoint what it is in this case that you think takes it out of the mode of proceedings category.
What takes it out of here is that the court gave all the information that the defense counsel needed to know what was contained in the note and to give a meaningful response.
But isn't it a premise of ORAMA that when you have a written note, all the information defense counsel needs is the full text of the note?
That is, in ORAMA, that was so because they decided that the language and the tone of the note is important. Here, with the numbers, there's really nothing more to be gained.
Well, of course, the numbers went count by count, right?
Correct, Your Honor.
And is it a fair guess that the lawyers trying the case knew which counts the people's case were stronger and which was weaker?
It might be possible.
And if you know that, and you look at the vote totals, you know which way the vote is going, right? Or at least you can guess with a high degree of probability which way the vote is going.
Well, here, the defense counsel was told that there were 3 separate splits, and considering there were 3 different witnesses, it's possible that defense counsel might have believed in one case he was winning, but in another case he might not. It still would have required a lot of guesswork as to which way the
But guesswork is part of a lawyer's job.
Well,
I mean, isn't it part of the whole point of ORAMA to let the lawyers who are pretty good at guesswork do their job?
Well, here, Your Honor, the defense counsel was told that basically here, I mean, it would have been the same thing as if the defense counsel told there was a deadlock. He still would have required guesswork. I mean, he was told there's a breakdown with the 3 split.
But if you're a defense lawyer and you're told there's a deadlock, that's interesting information. If you're told they're deadlocked 11-1, even if you have to guess which way they're deadlocked, that's different information. You have meaningfully more information, don't you?
Well, here there were 5 separate counts, and it wasn't 11-1 as to all 3. There were different votes as to each of the counts. So it still would have it would not have been a case of simply saying it's 11-1, so I need to get an Allen charge dependent on one person. There were counts where there was 10-2 and 8-4, so it wasn't simply guessing as to what that one 11-1 vote was. In any case,
if the 11-1 count had been the weakest in the indictment, a defense lawyer might have said, "Hey, I like this jury. I withdraw my motion for a mistrial." Isn't that a possibility? That is, if he read the notice saying they were 11-1 for acquittal.
If it's possible defense counsel could have done that, I mean, even just being told deadlock, defense counsel still had the option of asking for mistrial or just asking the jury to continue deliberating. He knew that there was a split in the votes, that there were 3 separate splits, so that there was not an agreement as to each of the counts. So the defense counsel knew this wasn't a case of a single juror holding out on all 5 counts, that there were differences. So he was given all the information that was needed, that the jurors are in disagreement as to all the counts.
What's your best case for supporting the position of taking this out of the arena of mode of proceedings error?
I believe it's People v. Starling, Your Honor, because this is, as in Starling, defense counsel was given all the information that was needed to make a meaningful, have meaningful notice of the contents of the note, and was able to give meaningful input.
It sounds as though you're merging mode of proceedings error with error. You're really saying that there was nothing wrong with what the judge did, and therefore it's not mode of proceedings error. If there's nothing wrong, we shouldn't reverse it at all, right? Even if they preserved it.
As in People v. Starling, where the judge does not, the judge gave all the meaningful notice of the contents of the note and gave defense counsel an opportunity to meaningful input, but did not necessarily follow
in Starling, as I remember it, maybe I'm wrong, as I remember in Starling, he read the note verbatim. It was just that he read it, he didn't give them advance notice. He read it with the jury sitting there. Correct,
Your Honor. And also in Starling, the judge didn't actually give defense counsel an opportunity to give input, but this Court still said it was an
Well, we said he did. It was a short opportunity. For a fast on his or her feet defense counsel could have given input.
Well, in that case, this Court held that it was fine because defense counsel knew what the Court's response would have been because it was the same question.
The defense lawyer had heard the whole note and had an opportunity to stand up and say, "Excuse me, Your Honor, before you go further, I request a conference."
And as here, defense counsel certainly had an opportunity to say, "Your Honor, I would like to see the contents of the note." The judge told defense counsel that there's a breakdown and that he was uncertain. This is not a case where the judge said, "I'm not disclosing it. I refuse."
I understand what you're saying. Wasn't that also true in Orama? The defense counsel had a chance to say, "I'd like to see the note, please," and didn't say it.
In Orama, judge never told defense counsel that he was summarizing the note. He never told the defense counsel that there was a split in the vote or what exactly was in the note. Judge merely stated that the note, he's not reading the note, but that it just merely states that the jury is deadlocked. The defense counsel was not made aware that there was more information that was an actual lengthy note.
That almost sounds like an argument, not that it was mode of proceedings error in Orama, but that in Orama there was adequate preservation because the defense lawyer didn't really know that an error had occurred until after the question had been answered. Is that what you're saying?
Well, in Orama, it was a mode of proceedings error because defense counsel was not told that there was something being resolved. He did not have an opportunity to. He did not know that he should have registered an objection.
Folks, on what I'm saying, usually when you say the defense lawyer didn't have a chance, the conclusion from that isn't mode of proceedings error. The conclusion from that is it's preserved. He objected as soon as he had a chance.
Your Honor, in most of the mode of proceedings errors, it was held that there's no preservation required because defense counsel obviously did not know that there was an error there. In that case, that is why it was.
To me, I'm sensing a logical contradiction between saying that there's no preservation required because you didn't know there was an error. If you didn't know there was an error, of course there's no preservation required. There's never preservation required for errors you don't know about.
Well, the more
Mr. Vaughn, you can answer that on
I'm
rebuttal,
sorry.
okay? Just keep it in your mind. All right. Ms. Keeling.
Can you explain why, even after the defense attorney was given the note, that there's still he doesn't say anything about it, he doesn't ask the judge to re-instruct the jury, he does nothing. Why should we still claim that that falls within mode of proceedings, when at that juncture he certainly had a full opportunity to comment?
Well, why defense counsel didn't comment at that stage, I don't know. That's speculative as to what defense counsel was thinking at that point. But the mode of proceedings
But it makes this case quite different from the normal mode of proceedings.
Well, it doesn't, Your Honor, because the mode of proceedings error had already been committed. It's the timing of the error that is critical, that this Court has made plain. This case is Orama and Kassoon, in that as soon as the jury had returned to deliberations, at that point the mode of proceedings error had been committed. The Court failed in its core responsibility when it did not provide counsel with the verbatim contents of the note before instructing the jury. Orama and Kassoon explicitly, they emphasize, before is even italicized in those cases, it is that defense counsel is the one who can best protect the rights of the defendant prior to the jury being instructed and prior to the jury returning to the deliberations.
I see a bit of difference because in the previous cases it's that the defense attorney, I mean, the fundamental concept underlying Orama is to have full disclosure and to give an opportunity for notice.
That's correct, the verbatim
It's not
content.
that this attorney didn't know that there were numbers for the jurors' positions here, but the defense attorney doesn't say anything. He doesn't say to the judge, I'd like to know what those numbers are.
Well,
Or can you ask the jury, can we send it back? He makes no recommendation at all and doesn't even object to anything after he sees the note. So this is a little bit different than our previous cases.
well, it's different in that defense counsel didn't object when the court told both counsel, that it was failing in its core responsibility by withholding the verbatim contents of the note. As Your Honors have noted, that information was highly informative, regardless of whether or not it stated that it was for acquittal or for conviction.
When you say it's highly informative, now you've looked at that note, what do you think was going on in that jury?
Precisely, Your Honor. That jury note, we know that, number one, they do return a verdict as to one of the 11-to-1 count. It parrots the verdict sheet both in terms of date and in terms of guilty, not guilty. And as all of Your Honors have noted, an experienced attorney certainly not only needs to know that information, that is precisely what ORAMA is. As this Court has said, it is difficult to imagine a situation in which a court would be justified in declining to show or read a juror's note to counsel.
And there's no obligation to say, I'd like to see the note.
It's motive proceedings error. It's the court's core responsibility. It's not defense counsel.
My question is, why is it motive proceedings error other than because ORAMA says so?
Because it's under CPL 31030, it's about the judge's role and defense counsel's role. This goes at a critical stage of the trial where it's the judge's role under CPL 31030 to fulfill its core responsibility.
Well, but isn't it a core responsibility of a judge to instruct a jury?
It is, Your Honor.
And when he does that badly, the error has to be preserved. It's not motive proceedings error.
Well, when it's the judge, it's not for the judge to decide whether or not that information is informative. Here, the judge says, I think it might be improper. But at that, it is counsel who needs to see.
I understand why it's error. Why is it so special error that we have to call it motive proceedings error?
Well, because it goes to.
You're tempted to say because ORAMA says so.
And I
Yes,
guess
Your
that's the
Honor.
problem. If we think it doesn't fit perfectly under ORAMA, why should we still call it motive proceedings error? I guess that's my basic question.
Because it's the critical stage of the trial, right? It's the post-submission. It's the deliberative process. This jury was deadlocked. They sent out 3 deadlock notes. This one is listing the splits. And as we know, any experienced defense counsel would have definitely formed an opinion as to what those numbers meant. And so it goes to the court, and the judge then instructs the jury with an Allen charge, which was intended, as in ORAMA, as in Kissoon, was intended to have an effect upon the outcome of the trial and upon the deliberative process. And so for that reason, it was inherently prejudicial. The counsel didn't see that very critical information.
If they were obviously trending, and it looks in retrospect that they were trending not guilty, because it was at 8-4, 10-2, 11-1, and then he was acquitted of all but one, right?
No, he was not acquitted. They were hung on the other 4.
Oh, I'm sorry, they were hung on all
So
one.
it actually was that they were tending towards guilt. It was the 8-4, the 11-1, 11-1, 11-1. Again, it also parrots the guilty, not guilty of the verdict sheet.
Okay.
So again, this was a very close case as well. I mean, this was the most critical point in the trial. And at the most critical point in the trial, defense counsel did not know the precise language of this juror note, which, as this Court has said, again in ORAMA, may be critical to counsel's ability to frame intelligent suggestions for the fairest and least prejudicial response, and it is defense counsel who is best equipped and most motivated to evaluate the inquiry, hear the numbers, and the proper responses in light of the defendant's interests. It's about protecting the constitutional rights of this defendant. And so where the Court withholds the verbatim, this Court has used the word verbatim. This Court has used actual specific content or specific content. So where...
You know what's strange about this is that most juries are specifically instructed not to give any numbers. assuming that that is likely to have happened here, what is it that you think the defense counsel could have done had he been able to see the numbers? You know an Allen charge is coming. What is it that, what more could you do?
Well, number one, Your Honor, in this case, that instruction was not given to the jury. So we do know that from the record. But what counsel could have done was made an alternative request. The only thing counsel does is ask for a mistrial. And his comments, I think, further support why ORAMA is fundamental, why this is motive proceedings error. In that counsel's concerned, he says, I'm very concerned here. They've reached an impasse. This is their third deadlock note. They're telling you they're split. He's speculating as to what those numbers are, as to what that split may or may not mean, those splits, those 5 splits.
And if he'd known, what would he have said?
He would have said, Your Honor, other than the mistrial, please give an emphasized instruction that the one not to give up their beliefs, just as in Kassoum.
He would have been more inclined to try to beef up the don't give up your convictions aspect of the Allen charge.
Certainly, Your Honor. And it's that he would have requested the further and an additional instruction. And we know that what the court...
And, you know, I think I understand, I accept your argument up to the point where then the court does give both the prosecution and the defense attorney the note. And then at that juncture, they see the numbers, and he doesn't say anything. So do we still say the motive proceedings taint covers that, and there's still no obligation to object? I mean, it seems to me we're encouraging attorneys to sit back and not say anything, and then you can claim motive proceedings, reversible error.
Well, 2 things, Your Honor. One, it's if the error could have been cured at that point, and the jury has returned to the deliberations room, we don't know. The reason why it's inherently prejudicial and motive proceedings error is because we don't know what is now going on in that jury room. For example,
but they were still deliberating, so he could have asked the judge to bring them back in the courtroom and re-instruct them.
But whether or not that would have even cured it is speculative because, for example, the jury could have taken, I mean, the first thing that they could have done is taken a vote and maybe reached on that one count that they did reach on. For example, we don't know. It's totally speculative. But the point is that if the error could have been cured by re-instruction, it was the court's duty to do so. That is what 31030 is about. That is why it is called the core responsibility of the court. It's not defense counsel's obligation at that point. When it's motive proceedings error, it's because it's the court's responsibility.
Okay, so you're saying we look at what the trial judge did or didn't do, not what the defense attorney
Precisely,
did or
Your
didn't
Honor.
do.
And so I would, again, state that this is a clear and routine application of ORAMA and Kassoum, and we ask that this Court please affirm the appellate division's decision.
Thank you, Ms. Keeling. Mr. Wan, your 3 minutes.
Your Honor, in ORAMA, it was a motive proceedings error because the judge did not disclose the full content of the note. The judge did not just only summarize it, but withheld vital information that could have aided the defense counsel in offering meaningful information. Here, the judge told defense counsel what he was doing. The defense counsel knew that there was a numerical breakdown and that the breakdown did not give any indication of what the outcome was and that there were 3 splits. And the judge even told defense counsel, do you have any input?
Isn't it possible, though, that depending on how it's trending, if counsel thought it was trending in their favor, they might say, don't give an Allentown charge yet, Judge. You know, let them deliberate further. It's only been 8.5 hours, whatever it was. And I don't want an Allen charge now.
Well, considering the court already had given an Allen charge, it's doubtful that the court would have merely just said to continue to deliberate and not issue an Allen charge. Moreover, defense counsel was shown the note immediately after the court finished instructing the jury.
Well, not to fence with you, but I mean, that's kind of the point. Defense lawyer might want to say, Judge, I think you gave an Allen charge. That's enough. Don't do it again. There are many defense lawyers that think an Allen charge means, will you hurry up and convict this guy so we can go home? I mean, they're not smiled upon by the defense bar, I don't believe.
Well, even without seeing the note, defense counsel certainly could have made that request. I mean, here defense counsel did ask for a mistrial. And then once the judge decided, denied the mistrial motion and stated that I am going to reissue the Allen charge, defense counsel did not object. He made no request that the court not issue an Allen charge, but they merely instructed the jury to continue deliberating. If there are no further questions, people request the case be remanded.
Thank you, Mr.